Welcome everyone, and thank you for joining us today on Level Up Law, where we here at South Carolina Legal Services are leveling up your legal knowledge on the different areas of law that we handle. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'll be the host of the webinar today, along with our producer, Kenneth Elliott from our IT department. We are joined today by South Carolina Legal Services Housing Law Unit Head, Attorney Mark Fessler from our office in Greenville. Mark will be walking us through the new eviction online classroom that we hope will help attorneys handling evictions, as well as those who are representing themselves. As you view today's presentation, please do remember that this is not legal advice, but just general information for the public. This classroom hasn't actually been published yet. We've been working on it for quite some time with a nice grant from Legal Services Corporation. And so we're looking forward to sharing it with you today and hopefully getting some good feedback so that we can launch it as soon as possible. Just remember, you should always consult an attorney for any specific legal issues that you have, and certainly that is true with eviction. At the end of today's presentation, we will provide information on how to apply for our free legal assistance here at Legal Aid and how to also access our public information and resources. As always, a recording of this webcast will be posted on our YouTube channel later this week, and you'll be able to see the run-through of the classroom. You just won't yet be able to access it. Again, thanks so much, everyone, for joining us. And Mark, let's check out this great new tool from South Carolina Legal Services.
All right. Thank you, Susan. Thank you for that introduction. And you really covered sort of the gist of what we're going to try to get into, which is our new residential eviction defense classroom. And hopefully y'all can already see sort of the landing page for that right there. Before we get into that, I've been asked to and wanted to give a plug for our low-income taxpayer clinic program. So, we always like to make you aware of everything that we're doing at South Carolina Legal Services. So if anybody has tax needs and they're a low-income taxpayer, maybe they're getting garnishments or whatnot from the IRS, you can apply to Legal Services, and we have a low-income housing tax clinic that can help address those needs. But let's turn now back to the classroom. So, in thinking about putting together legal information to put it out to the public, one thing we wanted to do is we wanted to provide information that was, more in-depth than what you might typically find when you just do a random Google search about evictions in South Carolina. And we also wanted to make the information specific to South Carolina law because, although every state has evictions and has laws, they differ from time to time, place to place. And so having something that is unique to South Carolina, specific to South Carolina, was important for us. And we also wanted to create a classroom that tried to answer some of the common questions we get and maybe resolve some of the common misconceptions that people have about, what a lease is or how eviction works and things like that. So as Susan said, this is sort of in development, and we're in our, let's call it a beta testing phase at this point. And so you're going to get a survey after this presentation, and if you would, it's just 3 questions, respond to that survey, and that'll help us with the feedback that we need to make the classroom better and to improve that classroom. And so what the classroom is, South Carolina Legal Services, we've already created a number of classrooms, and we host them on this website called lawhelp.org/SC. And you can see the classrooms that are already available for public consumption, from debt collection, guardianships, getting your landlord to make repairs. And when you click on a link to one of these classrooms, it'll take you to the same sort of landing page that we're going to go over for residential eviction defense. The only difference is the eviction defense classroom is not public, whereas if you wanted to learn about getting your landlord to make repairs, you can do so. So I just wanted to give you an idea of where that will be once it does get published on our Law Help website. So, the classroom starts off with an introduction. It talks about, we're going to talk to you about the basic steps that you can use if your landlord sues you for eviction. And it consists of individual lessons. They're formatted in an FAQ type setup. So, what laws apply, what are the reasons somebody can be evicted. And the classroom really assumes that you're at the beginning of the legal process. That disclaimer is important because we often get people coming to us who, have already been sued for eviction or who already may have had a hearing. And so, the classroom may not apply or all parts of the classroom may not apply to them. But if you are at the beginning of the legal process or seeking general legal information, you can start at the beginning. And so, we really start with the basics. What is an eviction? It's the legal process that a landlord uses to retake possession of a dwelling unit. And as you may have noticed from the getting your landlord to make repairs, there was a video appended, and we're going to have a video appended here. We don't have it uploaded to the system yet, of course, but we do have that video for you. So I wanted to show you sort of our world premiere of residential eviction defense, and you can respond to that as part of the survey. So once I play this, I think it'll mute everybody, and so enjoy.
An eviction is a lawsuit that a landlord must file to retake possession of an occupied residential rental unit. An eviction can be filed because your lease term has expired, you did not pay rent.
Oh, wait a minute. Sorry about that. All right, let's try.
An eviction is a lawsuit that a landlord must file to retake possession of an occupied residential rental unit. An eviction can be filed because your lease term has expired, you did not pay rent within 5 days of the due date, or you did not comply with some other requirement of the lease. Before filing the eviction, the landlord has to give you notices. In other words, tell you that they are planning to evict you and why. How eviction starts. Notice. For example, if you're being evicted for not paying rent, they need to send a 5-day notice telling you that they are planning to evict you. If you violated your lease, so long as the violation doesn't affect health and safety, they must send you a notice giving you 14 days to fix the problem. If your lease term expires, the landlord doesn't need to give you notice unless you're on a month-to-month or week-to-week lease, in which case the landlord needs to give you 30 days or 7 days notice that the lease won't be renewed. Once the landlord has sent the notice, he files something called an application for ejectment with a local magistrate court stating why you should be evicted. This starts the lawsuit. The tenant is notified too. It's called being served. The magistrate sends you a rule to vacate or show cause. The rule should inform you of the reason that the landlord wants to evict you. You then get 10 days to respond. You can respond in one of two ways. Either 1, vacate the property within 10 days after the rule is served on you, or 2, file something called an answer to request a hearing before the magistrate court within the 10 days. If you do neither, you'll be in default. The magistrate court will issue a writ of ejectment, which is the court order that says law enforcement can physically put you out. Basically, you lose automatically because you don't defend yourself. If you have reasons why you should not be evicted, called defenses, then it's a good idea to write these down in your answer and file these at the magistrate court as your response to the rule. A defense is a legal reason why you should not be evicted. Common examples are: 1, you did not do what the landlord says you did, including you actually paying the rent. 2, you did what the landlord says you did, but that does not count as a breach of the lease, like the landlord tries to evict you for having a pet, but the lease doesn't say you can't have a pet. 3, you did what the landlord says you did, and what you did breached the lease, but it's really minor. 4, the landlord did not give you all required notices. Defenses can be technical. You should consult with a lawyer for these. The hearing. After you request a hearing, the magistrate court will let you know when to come to court. The hearing is a trial. The magistrate will not investigate to figure out whether what your landlord is saying is true or false. You must be able to explain to the magistrate why the landlord is wrong. If the magistrate finds against you at the hearing, then he or she will issue that writ of injectment within 5 days of the hearing. The constable must physically post this writ to the property. This starts a 24-hour clock. If the unit is not vacant 24 hours after the writ is posted, law enforcement can return and physically evict any remaining occupant. Eviction cases can be challenging. We strongly advise you to seek legal advice or representation if possible.
Okay, Mark, be sure and unmute yourself now that the video is completed.
Yes, yeah. I'm getting the hang of these. This is my second time doing a presentation, so I'm getting the hang of these buttons and the show screen and stop showing screen and all that a little better, but not as fast as I'd like to be. So that was our video, and basically the idea was to try to give a brief summary for people who don't have time to spend going over all the classrooms, just to give them a brief summary of the high points of what they need to know about an eviction defense. But let's dig into the classrooms a little bit. So the first lesson is sort of what laws apply. The laws that apply to an eviction are 3: the lease, state law, and if you live in a federally subsidized property, federal laws also come into play. If you wanted to rank those, the lease is probably the most important. State law sets certain baselines. So if parties don't have a lease or if it's not written down, state law will add some lease terms. Some of those lease terms can be modified or waived by a written lease. So really the written lease is the place that you want to start for determining what your rights and the landlord's rights and responsibilities are. However, if you don't have a written lease, or if the written lease leaves out some terms, state law comes in and under the Residential Landlord-Tenant Act supplements a written lease and also has other terms. And so we have linked here a convenient link to the South Carolina Residential Landlord-Tenant Act. You can pull it up. It's fairly long, but it's here, and you can review the law that the magistrate, that the landlord, everybody is supposed to be following. Also, state law controls how evictions operate, the nuts and bolts of the actual process, how to file a lawsuit, how to effect service on a tenant, and things like that. And we've also linked that set of rules, that statutory section here as well. It's under South Carolina Code section 27-37-10. And so you can review what the actual law says about how the process is supposed to work. And federal law has a lot of complicated rules and regulations depending on which particular program you're in. It goes far beyond the scope of what we're trying to do or able to do in this particular classroom. And so we recommend that if you have a federally subsidized connection, public housing, a housing choice voucher, that you seek out counsel from an attorney to advise you on those particular situations. So what does the law say about why a tenant can be evicted? There are 3 reasons that a tenant can be evicted. 1, a failure to pay rent when due or demanded. 2, the lease term has expired. Or 3, the tenant has breached the lease in some other way other than non-payment of rent. Each of those different categories have different considerations that need to be kept in mind. So with the failure to pay rent, the general rule is you're required to pay on your due date. Most leases have a 5-day grace period, and state law has a sort of built-in 5-day grace period. You still may be subject to a late fee if you pay after the due date, but there's a slight grace period there. The due date should be written down in your lease, but if you don't have a written lease, or if the due date is not written into the lease, then state law supplements that term or adds that term to the contract, and it says that you're required to pay monthly at the beginning of each calendar month if your term is month to month, or it's less than month to month. If your rental agreement does not say what rent you're supposed to pay, the law says you must pay the fair market rental value for using and occupying the property. So if you're renting property and there's no specific agreement about what the rent should be, you still have to pay something, and the law says you have to pay the fair market rental value. Of course, determining what that is may not be easy, but it's not nothing. The lease term ending. So if you don't have a lease agreement that says how long you can rent the property for, then the law presumes that your lease ends at the end of each month and begins at the beginning of the next month. That's called a month-to-month lease. And that continues on until one party gives the other party written notice that the lease will not be renewed 30 days in the future. If you rent a room or rent by the week, then the lease ends and renews week to week. If your lease does set out a specific term, say 3 months, 6 months, 1 year, then the lease ends when the term ends. Now, sometimes you'll want to check your lease because a lot of times leases might modify that. It might say, well, this lease is for 1 year, and at the end of that year, it goes month to month. It automatically renews month to month. So in that case, the lease doesn't automatically end. But if a lease does not have a provision of automatically renewing itself, then the landlord is entitled to simply, at the end of the lease term, say, all right, your lease is over. We want you to vacate, and that's permissible. However, if the lease does end, but the landlord still allows you to remain there and to keep paying rent, that probably triggers the creation of a month-to-month lease. Then finally, the tenant can be evicted for a material breach of the lease. And I think this is important because not any breach of the lease can justify termination of that lease. The lease has to be breached in a way that is strong enough or significant enough that the law calls it material. And that means that it really goes to the heart of what the landlord-tenant relationship is, such as, having unauthorized guests might be a material breach of the lease. Damaging the property or letting the property, fall into disrepair, that could be a material breach of the lease. But an example of a non-material breach, I think, would be if the lease says something like the tenant is supposed to replace all light bulbs in the unit. Then the landlord inspects and finds one single light bulb burned out. The landlord can't turn around and say, well, you've breached the lease, we're going to evict you, because I would be surprised if any court found that to be a material breach of a lease. So then the next classroom discusses what does a landlord have to do before filing an eviction lawsuit. And the key thing here, as you saw in the video, is notice. The general rule is that the reason a landlord gives for terminating a lease has to be documented in some form or fashion in a notice. And the rules for terminating the lease, again, are found in the lease itself. So there's usually a provision in there that says, here's what happens if you default, or here's how the parties can terminate a lease, something to that effect. South Carolina Residential Landlord-Tenant Act talks about what you can do to terminate a lease. And then again, under federal law, there are some federal rules that come into play that we don't really have the opportunity to get to. The kind of notice the landlord has to give you depends on the reason the landlord wants to terminate the lease. And so remember, the previous lesson was there are only 3 reasons: non-payment of rent, end of lease term, or a material breach of the lease. So if you have failed to pay rent, the type of notice the landlord has to give you is one 5-day notice. That only has to be given one time during the entire time you're a tenant in the property, according to state law. And the non-payment of rent notice has to say something to the effect of this: if this is your notice, if you do not pay rent within 5 days of the due date, the landlord can start to have you evicted and you'll get no other notice. Now that language, or language similar to that, can be written into your lease. And if that language or language similar to it is in your lease, and the law also says that it has to be conspicuous, so it can't just be written in the same text, in the same format as the rest of the lease. It needs to be drawn out or highlighted, bolded, something like that, to set it apart. But if that language is in the lease, then that's the 5-day notice, and you're not entitled to a separate written 5-day notice. But if the landlord does not give a 5-day notice, and rent goes unpaid more than 5 days past the due date, the landlord cannot terminate the lease until they've given one notice. If the landlord wants to terminate the lease because you're at the end of a lease term, the landlord may or may not have to give a notice. Again, like we were talking about, for leases that are not month to month, that just are 3 months, 6 months, a year, those end on the date that the lease says it ends. And there's no notice required to terminate that kind of lease unless the lease has an automatic renewal provision, or unless the landlord has continued to accept rent well beyond the end of the lease term, which would convert it to a month-to-month lease. So look at the lease to see if the landlord has to give any kind of notice to terminate a lease at the end of the lease term. And then finally, material breach of the lease. If the landlord wants to terminate a lease because of a material breach, something that the tenant does that the landlord claims violates the lease or violates the tenant's obligations under the Residential Landlord-Tenant Act, there's something called a 14-day notice, a right to cure notice as it's commonly called, that's in the Residential Landlord-Tenant Act. And this means that if you have a violation that does not materially affect health and safety, then you basically get one opportunity to fix that problem or to not reoffend, let's say. So, for example, if you have an unauthorized guest living in the unit, you should get one 14-day notice saying you've got an unauthorized guest, that needs to be resolved. And the landlord cannot terminate the lease without giving that 14-day notice. If the issue is damages to the property, then the tenant has an opportunity to fix those damages within 14 days, or to at least start the repairs if they're going to take longer than 14 days, and pursue the repairs in good faith during the 14-day window and complete them in a reasonable time thereafter. So those are for material breaches of the lease that do not affect health and safety. If you breach the lease in a way that threatens health and safety, the landlord can require repairing, replacement, or cleaning the damaged items as quickly as conditions require if the issue is an emergency. So let's say you're renting a single-family house and the lease requires you to maintain the appliances, which is permissible under state law if you're renting a single-family house, even if the landlord provides them. And let's say there's a problem with this, a gas stove, and there's a gas leak issue. The landlord could require that to be fixed sooner than 14 days because clearly that would pose a health and safety risk. The landlord does not have to give the 14-day notice for non-payment of rent, or if you are conducting illegal activities or permitting illegal activities in the dwelling unit. So those are the notices required under state law. Federal law also has some additional notices for people who occupy Section 8 or public housing. Those notices are much more detailed than the ones required under state law and go beyond the scope of what we're presenting here in this classroom. So let's move on to how an eviction starts. So after a landlord terminates the lease upon giving proper notice, then an eviction is allowed to begin. An eviction lawsuit begins once the landlord goes to the magistrate court and files something called an application for ejectment. The state of South Carolina, the judicial department has put together sample forms that are used. And so we've linked to those forms, and you can see examples of what the documents are going to look like. So if we pull up the application for ejectment, this is what the landlord has to file, or this is what the landlord will fill out when he goes to, or he or she goes to the magistrate court. It says, I, so-and-so, am the plaintiff, state that I'm a landlord lessor. I further state that a landlord-tenant relationship exists between myself and the defendant, whatever the defendant's name is, and then the grounds for ejectment. And it's sort of a checkbox, but it's one of those three grounds. Fails or refuses to pay rent, the tenancy has ended, or the terms or condition of the lease have been violated. So the landlord files that, and then based on that application, the magistrate will issue something called a rule to vacate or show cause, which looks like this. And all these, of course, blanks would be filled out. And the landlord says, that to the tenant, to the defendant, the landlord is asking the court to evict you from property located at, and I'll give you a property address, because, and then it should include the same information that the landlord put in the application for ejectment. And then it says you, the tenant, are required to do one of two things. You either have to vacate the premises, or within 10 days, you have to contact the magistrate. It'll have the magistrate's contact information within that 10-day period for the purpose of scheduling a hearing to show why you should not be evicted. And at the bottom here are some entries for where the sheriff or magistrate's constable who serves the rule to vacate is supposed to note the attempts made to serve it, and then finally the date of service, because the date of service again will trigger your 10 days to respond. So we have those documents linked at the bottom of this lesson. And it's pretty straightforward. That's how an eviction action starts. So once you get served with the rule to vacate, you have 10 days to respond to the rule to vacate. This lesson, I'm not going to go through it in detail, but it kind of gives you the ins and outs of how service of a rule is supposed to operate. We get a lot of cases where we ask people, well, when were you served with the rule, the rule to vacate? Well, I don't know. It was on my door today. I found it today, but they said they served it 3 days ago. So there's a lot of confusion about how service is supposed to happen. And I think that, it's not just a tenant thing. I think perhaps some magistrate courts or constables may not be entirely serving it correctly. They're supposed to make 2 attempts to serve you in person. They're not supposed to just show up and paste it on the door and leave. They're supposed to make 2 attempts to serve you in person. And if they can't get you in person, and those in-person attempts are supposed to be separated by, some time. They can't, do it at like 10 o'clock and then try it again at 11 o'clock. But if they can't get you twice in person, then they're supposed to mail it. And 10 days after the mailing date is when the 10 days to respond starts. But if you're served in person, the 10 days starts, of course, on the day you get served. So how do you respond? The way to respond, kind of what the statute says, is that you have to appear and show cause. It says you have to appear and show cause why you should not be evicted within 10 days. So typically in a lawsuit, a defendant will fill out something called an answer, and they will submit a written answer to the court listing their response to the rule to vacate. So if the rule to vacate said, well, you failed to pay rent, the response might be, I did pay rent, or you're charging me, what you're charging me for is not rent, you're actually charging me for something else. So it's not a rent issue at all. So magistrate courts have different, policies about whether they'll allow you to require you to file something in writing or not. Some magistrate courts do require something in writing. Other magistrate courts may allow you to just pick up the phone, call the court, and request a hearing. What I would recommend before you do either of those is decide whether you intend to seek legal advice or legal representation about your case. Because if you go ahead and contact the magistrate court, they're going to schedule a hearing, and that may prevent you from certain rights like requesting a jury trial. And so it's best to go ahead and use the 10 days to seek legal counsel if you intend to do so. Because if you do retain an attorney to represent you in the eviction action, the attorney should respond to the rule for you, or at least give you guidance about, how to respond. So, there's also a conversation about whether you should submit something in writing. An answer, which is a written response, is useful because it can inform the magistrate court about why you think you should not be evicted. However, there's a potential drawback to a written answer in that if you later get an attorney to represent you and that attorney wants to change your answer, the court may not allow the change. But there is a rule in the magistrate court rules that says the court should be lenient in allowing you to change your answer. So this is something of a judgment call. And it also depends on what the magistrate courts require you to do in your jurisdiction in terms of either submitting a written answer or not. So let's move on to some possible defenses that you might have in an eviction action. So the video mentioned some common ones, being that you didn't do what the landlord says you did. I didn't have an unauthorized guest. I have a friend that visits frequently from time to time, but he's not living here. You did what the landlord says, but that doesn't count as a breach. So, the landlord says you have, a dog, but there's nothing in the lease that says you can't have a pet. Nothing in the house rules that says you can't have a pet. You didn't materially breach the lease, or the landlord didn't give you all required notices. So those are some common defenses that we look at. Another common defense is called waiver. So what a waiver is where if one party is aware that they have a legal right, so if the landlord is aware that you breached the lease, and the landlord is aware that they can then take steps to terminate that lease, and they don't do it. They say, well, don't worry about it, or we'll overlook it this time. The landlord can't come back later and say, you know what, I've reconsidered and I want to hold you accountable for that lease violation. In that kind of context, the landlord would have waived the breach, and that is a valid legal defense. And so then we give, an example of a situation where the lease says you cannot have somebody living with you, and then, the landlord knows the friend is occupying the property. The friend later moves out. The landlord can't, months down the road say, you know what, I want to evict you for having that person living there who was not supposed to be living there. And in any event, the landlord is still required to give you the 14-day notice advising you to have your friend leave the dwelling. Now, this is something that comes up a lot. So we often get evictions where instead of the parties being in a landlord-tenant relationship where one party is leasing and the other party is renting property, we get situations where somebody is buying property. And sometimes sellers will use contracts or write things into their contracts that talk about how if there's a default, they can treat everything as rent, and then they'll go to magistrate court and try to have the person evicted as a tenant. This is not proper. The magistrate court does not have the authority to hear disputes over real estate unless there is a landlord-tenant relationship. That's why in that application for ejectment and the rule to vacate and show cause that I showed you earlier, there's a provision in there that says, I am in a landlord-tenant relationship, because if there is no landlord-tenant relationship, if it's a buyer-seller relationship, the magistrate court does not have the authority, or what lawyers call the jurisdiction, to hear that case. And so your defense to that would be, we're not in a landlord-tenant relationship. The kinds of documents that are, the kinds of titles that we see on documents that indicate a sales arrangement are things like bond for title, land sale contract, sometimes rent to own. Titles are useful in helping you quickly orient yourself to what the document's about, but you really need to read all the terms of the document and understand how the transaction works in order to know whether this is a lease situation or primarily a sales situation. So there's also one thing to keep in mind. If you do claim title to property and that's your defense, hey, I'm buying this, I have some sort of title to this property. I've paid, $20,000. I put down $10,000 as a down payment, something like that. You have to put it in writing, and you need to do that. You need to raise that issue when you respond to the magistrate court. There's also a statute that requires you to fill out something called an undertaking and to provide it to the magistrate court at the time you file your answer. I know these rules are technical, but they're out there, so you should be aware of them. What the undertaking says is that if the court dismisses this particular eviction, because it shouldn't be an eviction, it should be brought in a different court, then you agree to accept service if the plaintiff refiles that action in the proper court. And if you don't accept service, then your surety, you'll have to have somebody sign as a surety, will be liable for a $100 penalty. And so we've also included a document here that you can print and fill out that constitutes that undertaking. And it says, I, the defendant, make this undertaking, and if the plaintiff within 20 days deposits with the magistrate a summons and complaint for an action filed in the circuit court, that's the court where these kind of disputes, where these kind of real property disputes would have to be addressed, then I agree to accept service. And then the surety fills in the name and address and is liable for $100, and the court should sign that. So just to alert you to that sort of quirk of this particular defense. Now, we often get the question about, well, you know, either I withheld rent because the landlord didn't make repairs, or, you know, just the landlord hasn't made repairs like I asked. What can be done about that? In those kind of situations, it's possible that you might have something called a counterclaim if your dwelling unit is not fit and habitable and it's the landlord's fault. So going back to our classroom on getting your landlord to make repairs, that classroom goes into detail about what the landlord's obligations are in terms of keeping the property fit and habitable, and what you must do to ask the landlord or to get the landlord to make repairs. So this lesson right here really is more useful in the broader context of that other classroom. And so, and we've linked that classroom right here, so you can, you know, click over there to refresh your memory, or to go over sort of what you need to do to get the landlord to make repairs. One thing that comes up is the repair the type of thing that the landlord is required to resolve? And generally speaking, the landlord is required to maintain the property fit and habitable, but there's no precise definition as to what fit and habitable means. And the landlord is also supposed to comply with building codes requirements that affect health and safety. At a minimum, these things mean that the landlord has to make sure that essential services in the house work. Essential services are defined by law. Essential services include running water, hot water, heat. You know, note there that it does not include air conditioning. Air conditioning is not defined as an essential service. If the landlord does provide a working AC unit, then usually the landlord is required to maintain that AC unit in working condition. Essential services also include sanitary plumbing and sewer systems. So, you know, no leaking toilets, no leaking pipes, etc. Those stopped up sewer systems, operating electrical systems, and gas, if gas is used for heat, hot water, or cooking. The landlord is supposed to supply and maintain any appliances that are necessary to provide running water, heat, hot water, electricity, and sanitary plumbing and sewer. And then if the landlord provides appliances, the landlord is supposed to maintain those appliances, because it's presumed that that's part of the rental agreement, that you're not just renting the house, that you're also renting the appliances provided with the house. But the rental agreement, the law allows that the rental agreement can exclude these appliances in certain circumstances. So appliances needed for essential services cannot be excluded. So you can't say that the tenant has to maintain the HVAC unit if it's necessary for heating the building. So what happens if the landlord does not fulfill these duties to maintain the property? Generally speaking, the tenant has to give proper notice before a tenant can make a claim for damages against the landlord. How that ties into an eviction is a claim for damages could be used to offset unpaid rent. So if the landlord is suing you for unpaid rent and you have a claim for damages, the one can offset the other. And if at the end of the day you owe nothing, or if the landlord owes you, then you should not be evicted for unpaid rent. And again, referring you back to the classroom on getting your landlord to make repairs, that'll give you information on how to do that. How do you assert a counterclaim? So a counterclaim is a particular type of legal action where you're claiming against the person who is suing you. So an eviction in legal speak is in a sense called a claim, and you're filing a counterclaim to that. To raise a counterclaim, you have to file a written answer with the magistrate, or if you go to the magistrate's court and you say, I have a counterclaim, the magistrate court rules say that the magistrate court or their staff are supposed to take down and write down your statement. And at the end of this lesson, I'll show you what a counterclaim form looks like because the court administration, South Carolina Judicial Department, that is, has created forms that you can use. To prove your counterclaim, you'll need to think about what you need to prove your counterclaim. You need to be able to explain exactly what the repair is. So you can't just say, you know, I asked for repairs and they were not made. You should say, I asked for this repair, that repair, and be able to list them out. You should be able to explain what notice you gave to the landlord about the need for repairs, and also when you gave that notice. So if your evidence is, well, I talked to the maintenance man one time, it might have been last month, it might have been 2 months ago, that's not great evidence. Ideally, what you want is something in writing with a date of when you wrote it out, somewhere you can prove when you delivered it to the landlord, because the landlord also has a 14-day period to make repairs before the landlord can be responsible for not making repairs. You also need to know what your damages are. So even if the landlord failed to make repairs, if you have not been damaged by that, then you wouldn't be entitled to any kind of recovery, and therefore you wouldn't be entitled to any kind of set-off. So you need to know these three things at the time or before you file your counterclaim. You'll also need photographs and witnesses. That's important because, like the video said, the magistrate is not going to investigate your claim to find out what happened. You're going to have to provide that proof to the magistrate. Make sure don't use originals. Take copies so that you can keep records of what you submit to the court. And as we also talk about, how do you calculate damages? I won't get into all that sort of when the classroom launches. This gives you some ideas on how you can think about what your damages are, but basically it's any money that you're out of pocket because the landlord didn't make repairs. It also might include a reduction in the fair market rental value of the property. So if you're paying $800, but due to the lack of repairs, it's only worth $500, you might have $300 per month in damages. And so if you want to file a counterclaim, this is a copy of what that looks like. If I can drag it over. And again, these forms, they're also found on the South Carolina Judicial website under their forms section. And so it says the defendant has a claim against the plaintiff in the amount of, X dollars, the counterclaim, and then you just sort of summarize what the counterclaim is about. And you file that at the magistrate court. Another common question we get is about something called self-help evictions. Is the landlord allowed to, before a court has said that the landlord can go ahead and displace an occupant, is the landlord allowed to change locks or do something that makes it impossible or difficult to live in the property, such as disconnecting utilities or doing something else, harassing you to the point where you can't stay in the property? This is called a self-help eviction. And self-help evictions are unlawful. The court calls it an unlawful ouster or constructive eviction. These are not allowed, and these are pretty straightforwardly a violation of the law. If the landlord does it intentionally or willfully, then, if the landlord does a self-help eviction intentionally or willfully, you can usually get damages of up to twice your actual damages or 3 times your monthly rent plus attorney's fees. I just wanted to point that out because that question comes up a good bit. We also get a question about landlord retaliation. What is retaliation? So retaliation is very specifically defined under the law. Many types of retaliation are illegal, but not all of them. So if you make a complaint, first of all, the retaliation statute is triggered only if you make a complaint about the condition of the property, either to the landlord or to a government agency that is tasked with maintaining, say, building and housing codes or some sort of quality code requirement. So for federally subsidized housing and urban development maintains housing quality standards, so you could complain to HUD and that would qualify as a government agency. But if you make a complaint, about the property's condition or about repairs that need to be done to the landlord or to a government agency that is tasked with handling those complaints, then the landlord cannot do 4 things. 1, the landlord cannot raise your rent above fair market value. Oh, you want to complain about the condition? Well, pay another $200 a month. The landlord cannot decrease your essential services. That's the water, hot water, gas, electricity, plumbing, and sewer. The landlord cannot turn around and file to evict you unless the landlord has a legitimate independent reason to do so, such as non-payment of rent. That's something we see, a fair amount. Or if they cannot refuse to renew your lease because you complain. There are limitations on the landlord's refusal to renew the lease. So if the landlord does one of those four things, you're allowed to raise retaliation as a defense. However, it's very important because you have to notify the landlord in writing within 10 days after you're served with the rule that you intend to raise a retaliation defense. If you don't raise a retaliation defense, you still should be able to file it as a separate cause of action in a separate lawsuit. So if you want to raise a retaliation defense, you're required to write down your defense in an answer to the rule. And if you prevail, the magistrate can award you 3 times your monthly rent or twice your actual damages. So if the landlord has said you failed to pay 2 months rent and you raise a valid retaliation defense that entitles you to 3 months rent, then you're really 1 month ahead and you shouldn't be evicted on the basis of non-payment of rent under that hypothetical. The landlord might do other things that seem like retaliation, but that might not be legal. The landlord might be more difficult to work with or become stricter about certain things that the landlord otherwise had let slide. These are not illegal forms of retaliation. And so even though they're frustrating, they don't violate the law. So those are some defenses and some counterclaims to think about. But back to the nuts and bolts of how an eviction works. How do I prepare for court? Even though evictions are called summary proceedings, meaning they're supposed to happen quickly, they do require preparation because it is a trial. And there are many things that can occur. It's difficult to know exactly what's going to happen at a trial. There are some instructions that the South Carolina Supreme Court has approved for use. These instructions are supposed to be served to tenants with the rule to vacate or show cause. There's a specific South Carolina form number here. So they're supposed to be served with you, and they give you information, just very basic information, such as the court will not telephone a witness. The witness has to come in. The court will not reschedule a witness because a witness is unavailable if you have not subpoenaed the witness. Talks about how to issue subpoenas or how to request the issuance of a subpoena, etc. So those are some basic instructions. But I think the two things you want to keep in mind is you want to know what your argument is, and you want to prepare your evidence to support that argument. And you want to be very conscientious about keeping things separate. So really, you should write down an outline of what you want to argue. If the landlord claims you didn't pay rent, write down what your defenses are, such as I did pay rent, or the landlord allowed me to skip this 1 month and allowed me to catch up later. So the fact that I didn't pay March, was not a breach, or the landlord waived that breach. If you have multiple defense, write them all down because this is your only opportunity to get out your defenses to the magistrate. Preparing your evidence is also very important. Not only must you know what you want to argue, but you have to have the evidence to prove it. You must be able to produce testimony or documents that will support your claims. Testimony can come from you, or it can come from any witness on your behalf. If you plan to testify, take time to think about what you want to say in order to prove your defense. For example, if the landlord claims that you breached the lease by letting somebody live with you, and your defense is that the landlord knew all along, then you will want to talk about how, what's the first time the landlord met the guest? Does the landlord, the landlord knows the guest by name? You'd be able to describe other situations that could prove that the landlord knew about the guest and let it go. Also, the more precise you can be with dates and times in conversations, the content of conversations, that is, the more credible you're going to be. Because a lot of this might come down to a he said, she said. So if you say, well, you let me do X, Y, and Z, and the landlord says, no, I didn't, the magistrate has to make a decision as to who to believe. And the more precise somebody can be with the dates that things happened, specifics about what happened or what was said, the more credible that person is going to come across. Also, if you plan to have a witness testify, be sure you talk to the witness about what the witness actually does or does not know. I mean, you may think that somebody knows what happened because they were there when a particular incident happened. But if you haven't talked to the witness and say, what do you recall about this? Who was the person that used that curse word? It wasn't me. The landlord claims that I used the curse word, and they're trying to evict me for disruptive behavior. But what do you remember about what was said? Be sure to talk to the witness and understand what the witness is going to say, because if the witness is going to say something that hurts your case, you're going to be stuck with it if you allow that witness to testify. And finally, as part of the preparation, be sure you have documents that you want to use. So if the issue is non-payment of rent or payment of other monies, you want to have copies of receipts, canceled checks, bank statements, money orders, things like that to show where you did pay, the date you did pay, so that you could challenge that. If the landlord has, for example, a no pets rule in the lease, but you have texts where you say, hey, my friend's dog is over here or something like that, and the landlord says, okay, no problem. You want the text. So basically, you want to try to document, everything you can in case you're going to need it later on in an eviction hearing. Question about jury trials comes up. And jury trials are permitted in South Carolina. You do have a constitutional right to jury trials in many types of lawsuits. And a couple of things, though, there really needs to be a legitimate dispute of fact. So if it's an issue about whether your lease term has ended and it's undisputed that the lease says it ends in a year, it doesn't automatically renew, nobody's tried to renew it, and it's just over, you're probably not going to get a jury trial because there's not really a dispute of fact that a jury has to make a judgment call on. The second thing, and this is probably most important, you have to request the jury trial in writing, and you have to request it at least 5 business days prior to the initial trial date. So if your trial date is set for Monday, then you need to request the jury trial in writing no later than the previous Monday, because weekends don't count, it's business days. One common problem that comes up is if a tenant receives a rule to vacate or show cause, they'll automatically contact the magistrate court, and the court will go ahead and schedule a hearing. Well, if that hearing is less than 5 business days or working days out, the tenant has at that point waived his or her right to a jury trial. So the best practice is, do it in writing at the time you provide your answer to the magistrate court. Just something that says, I request a jury trial, or if you're going to consult legal counsel and you want to try to retain an attorney, let the attorney make the judgment call after talking to you about whether requesting a jury trial is appropriate in your case. So that would be our recommendation on that. But this lesson just gives you some tips on what you need to do to request a jury trial. Mediation, we put this in here. So in magistrate court, where a jury trial has been requested, mediation is mandatory in 4 counties in South Carolina. That's Greenville, Kershaw, Lexington, and Richland. So if you live in one of those counties, requesting a jury trial can trigger the mediation process. Mediation, for example, in Greenville County is held regularly at the North Greenville Summary Court. Right now, due to COVID, the mediations have been much less frequent, and they are being held virtually to the extent they are being held. But it used to be prior to COVID that once a month, mediations would be held at the North Greenville Summary Court. Everybody would show up, and they'd have some volunteer mediators that would help the parties try to work out their differences. Because mediation is not mandatory that you come to an agreement. It's mandatory that you participate in the process, but a mediator has no authority to require the parties to come to any particular agreement. And so what happens if you go to court? We try to hear just to give you an idea of what will happen at the actual hearing. And we're thinking about shooting a video, maybe showing a mock bench trial, just to give people a visual of how that would go. But basically, the magistrates generally will start with the landlord. Why are we here? What happened? And you're given an opportunity to respond to that. And the landlord has what's called the burden of proof. That means the landlord has to prove that you did violate the lease in some sort of way. One thing landlords like to do, if they're not getting any traction, let's say they sued you for non-payment of rent, the landlord might start talking about some other issue. Oh, well, you had an unauthorized occupant living there, blah, blah, blah. But if the landlord did not sue you on that basis, that's not a proper issue for the trial. And it's entirely appropriate to say, Your Honor, I object. This information was not put into the rule to vacate or show cause. I'm being sued on a non-payment of rent issue. I'm not being sued on some other issue. That's a perfectly valid objection. After the landlord presents his or her evidence, you'll have an opportunity to present your defenses or counterclaims, and you want to be clear and concise and organized. That's why we recommend sort of coming up with an outline of the arguments you want to make and the evidence that will support your arguments. Because judges really, they have a tendency for you to get to the point, And so you don't want to ramble. You don't want to go on and on. You don't want to talk about every grievance that has come up during the relationship, or during the tenancy with the landlord. You sort of want to get to the point and focus on what's important to the judge. If you've requested a jury trial, that means you'll have to select a jury, and then it'll be the jury's job to decide factual disputes. So if the landlord claims that you violated the lease by having an unauthorized pet, and you deny this, instead of a judge deciding that issue, if you request a jury trial, then a panel of jurors will decide that issue. If you lose at the eviction hearing, what happens? So if the magistrate court rules against you, or if you have a jury trial and the jury rules against you, the next step is for the magistrate to issue something called a writ of ejectment. A writ of ejectment is a document that will be obtained by the landlord and then posted to the property. This is an example of what, this is what a writ of ejectment, this is the authorized form for what a writ of ejectment looks like. And it basically says that you have 24 hours to voluntarily vacate the premises. And if the premises are not unoccupied after 24 hours, a deputy sheriff may enter the premises using only the force necessary to effectuate the ejectment. This is, writ of ejectment. This is also the order that allows law enforcement to conduct a set out. So like the writ says, it has to be served to the property, it has to be given to the tenant, or it can be served in posting or in person, or by posting it on the front and back door, or in the most conspicuous place on the building. That starts a 24-hour clock. 24 hours later is when the sheriff's deputy can come back and actually effectuate that ejectment at the property. Law enforcement does have some discretion to extend the ejectment if there's an elderly or ill tenant, but it's up to the deputy's discretion. Who knows whether they will or will not exercise that. And then finally, let's talk about what do you do if you lose, but you disagree with the court's decision. Basically, you can appeal. You have 30 days to appeal to the circuit court. You have to file something called a notice of appeal. And we've linked here to the South Carolina Judicial website, which apparently that link does not work. So that's something we'll definitely need to correct. So we'll get that fixed. But you have to fill out a notice of appeal. You then have to file that appeal with the circuit court. You have to provide a copy of the appeal to the magistrate court. And not until you do that does the writ of ejectment get stayed. So you have to file the appeal and serve it on the magistrate court, and also serve it on the landlord, that is, before that writ of ejectment will be put on hold. Once the writ of ejectment is put on hold, the court will hold a what's called or require you to fill out an undertaking. You can fill out the undertaking and submit it with your appeal. That's probably the best practice. Some courts will hold a hearing after an appeal is filed to order the tenant to continue to pay rent while the appeal is pending. Because if the tenant misses a rent payment while the appeal is pending, then the tenant loses the right to appeal and the appeal gets automatically dismissed. So that's very important. And that's the undertaking. It's filing the appeal and then filing the undertaking will trigger a stay of the writ of ejectment. Once you file the appeal, the magistrate is supposed to prepare and send to the circuit court something called a return. The return is where the magistrate court explains what happened at the trial and why the magistrate or the jury ruled the way it did. And that's the record that the circuit court will review to determine whether the magistrate's decision was proper or not. And we have some forms linked down here with some instructions for filing a pro se appeal that will be linked at the end of that lesson. And then we just talked about this a little bit. If I file an appeal, can I be put out? No, if you file that bond or that undertaking, that puts the writ of ejectment on hold. And as long as you pay your rent within 5 days of the due date, you should be good to go. And then finally, we'll have a link to the materials and forms that we've had throughout all the other lessons. They'll all be linked at the last lesson there. And so with that, that is the end of our classroom. We hope to launch that later this year and put it up on that Law Help website later this year. And we hope it'll be very useful. And if you have made any notes or have any feedback that you can provide us or would like to provide us, we'd love to hear it. So with that, I will turn it back over to Susan Ingalls.
Mark, thanks so much. Wow, that was an excellent sneak peek into this online eviction classroom. That thing is chock full of important information. I can't believe you got through it in an hour. But we do hope to launch it sooner rather than later. So let me just, as well as thanking you, I do want to take a moment to thank Diane Lee of WSPA TV, who provided the excellent voiceover for the animation that you showed at the beginning. Each of our classrooms has one of those, and it's a wonderful little simple way that we can share the basics of what happens in an eviction or any other kind of action. So thanks to Diane Lee for her help on that. And thanks to all of you who joined us today, for sure. We certainly do appreciate your interest in this subject matter and all the other subjects that we cover in Level Up Law. Just remember, a free webcast every Tuesday at noon, and you can find out about the common legal issues that we see here at South Carolina Legal Services. Now, they can all be found on our YouTube channel, so just go to the Level Up Law playlist on our YouTube channel at SC Legal Services. Yeah, and also if you found Mark's classroom presentation helpful, be sure to go to Legal Services on YouTube and give it a thumbs up and share it with others. I'm sure there's a lot of people out there right now who will find this to be of great interest. Okay, if you have an issue and you need legal assistance or you want to get further information about this, please do go to our website at www.sclegal.org, and to apply for services, 888-346-5592 between the hours of 9 and 6 on Monday through Friday, but also you can apply online 24/7. Also keep an eye on our Legal Services Facebook page and follow us on Twitter and Instagram to see what's coming up each week on Level Up Law. Next week, we will be discussing how to open an estate in South Carolina Probate Court. So that will be a really great presentation by one of our attorneys here in the Greenville office. Now, I do want to remind you, Mark asked that you fill out a survey that you'll receive as an attendee of this presentation. And please do that. We need to know things like, was this an understandable classroom? Was it helpful to you? And also just sort of a free response question where we want you to really give us feedback. Things like, was this too much like school when you looked at it, or was it pretty easy to understand? Those are the kind of things we need to know so we can hopefully tweak it and do anything we need to do to make it better before we put it out there on learnthelaw.org. Well, thanks again for tuning in today. We look forward to having you back with us next week for how to open an estate in South Carolina Probate Court. Take care, everybody. That concludes today's webinar. Thanks for tuning in.